I feel a little like I did about 10 years ago when there was an effort in Congress to pass an asbestos bill, and I was invited to testify. I was thrilled to be invited to testify before the congressional, I think it was a Senate committee that was considering that legislation. And I went out to Washington, D.C., and I sat there, and there were representatives of the insurance industry who were present. There were representatives of the building trades industry who were there. I think my friend Victor Schwartz was there as well. There were representatives of unions that were there. They all testified to, I guess, half a dozen members of Congress and their staffers. And then it was my turn at the end, and I got up and I said, well, I want you to all know I come here not representing anyone. And I could see eyes glaze over. A few staffers left the room. They didn't care about what I had to say because I was just coming to speak on my own. And I guess I'm unusual in another respect. Bill, you were talking about judges at least spending their lives avoiding asbestos. As a young law teacher at the University of Iowa in the early 80s, Robert Parker, who at the time was on the Eastern District of Texas, trying to manage a docket that was just, the problem was it was like cleaning out the stables of a GIS, right? Every case he got rid of, there were 3 more there to replace it. Docket kept growing instead of being able to make any impact on that asbestos. And what he tried to do was use collateral estoppel in order to reduce the number of cases he had. And a colleague of mine said, Mike, look at this. He said, he can't do this, can he? Well, he had. Although, unfortunately, a few months later, the Fifth Circuit told him he couldn't do that. And in fact, there hasn't been any collateral estoppel in asbestos basically since then. Bill said that the principles are all the same across toxic tort cases. And to affect what academics do, let me say yes and no. Yes, I think that the causal principles that are applicable, and I want to spend some time talking about that. The causal principles that exist are applicable to all toxic torts. But I think each case congregation, asbestos, Vioxx, Agent Orange, there will be more in the future. You had a few of the current ones up on that slide, Bill. Present different problems, both because of the way in which they cause disease, what competing causes there are, and the state of the science and how good it is in illuminating those factors for us. And in that respect, I have to say, I think asbestos, if not being unique, is unusual and not entirely representative in the legal issues that arise there. So what I want to do is spend a little time on what I do think is universal. Not a little bit of time, I want to spend significant time on what I do think is universal. When we say causation, what do we mean? Bill, you were using that often. John, you are adverting to it frequently. What do we mean when we say that something caused something? And I want to stop for a moment and say, Bill, you have an article by David Eaton that you recommended as being a good source on epidemiology and toxicology. The first source I would look at, if I were a judge, is the Federal Judicial Center's publication, which many of you may be familiar with. I know federal judges know about it because it was initially produced for federal judges, but it's certainly gotten out to the state judiciary as well. If I had a case that had almost any scientific issue involved in it, I would look to the Federal Judicial Center's Reference Manual on Scientific Evidence. It's called the Reference Manual on Scientific Evidence. It's actually available for free on the Federal Judicial Center's website. I think that's fjc.gov, fjc.gov. That manual is a manual of chapters about different aspects of scientific evidence. There's a chapter on epidemiology, there's a chapter on toxicology, there's a chapter on regression analysis. The last one is the second edition that was issued in 2000. The third edition will be out in the next year or so, I expect, and will be expanded. It's going to be 2 volumes. It is a joint effort of the Federal Judicial Center and the National Academies of Science. The National Academies of Science is providing its process, its peer review process, to improve beyond what the Federal Judicial Center managed to do. You will see, at least in federal cases that address these issues, you see repeated references to the Federal Judicial Center's Reference Manual on Scientific Evidence. Okay, so what do we mean when we say X caused Y? Well, I think in most instances, what we mean is what we might call a but-for relationship, or that it was necessary, a necessary condition for the outcome, okay? That I am here today, it is the fact that I was invited by the Northwestern Law Judicial Education Program. It is a cause of my being here, because without it, I'd be a trespasser. That is a cause of my being here. Without it, I wouldn't be here. But that's not the only cause of my being here, and if there's one thing that I get across this morning, because it's a common mistake, I see this a lot, and I see this in my students who come in, I think, thinking that there is the cause for every outcome. Well, no. There are a number of other reasons without which I would not be here this morning, right? If I had not chosen as a young academic to pursue asbestos, I wouldn't have gotten the invitation, and I wouldn't be here. The point is that there are always multiple necessary conditions for an outcome. Multiple necessary conditions for an outcome. The question in a legal case is whether the defendant's tortious conduct is a cause of the harm, that is, combines with whatever else. And we know that not everybody who gets exposed to asbestos suffers mesothelioma. In fact, it's only a small proportion of people that get exposed to asbestos at any given exposure level that will develop mesothelioma. Why? Because there are other things going on in the world. And it probably has to do with something internal to the person rather than external, that has to do with genetic predisposition or other aspects of that individual that are necessary conditions for them to develop mesothelioma along with the exposure to asbestos. Let me talk for now about causation in these toxic cases by focusing on what I would call signature outcomes or signature diseases. And what do I mean by signature disease? I mean that the disease doesn't develop without exposure to an agent, a specific agent. So, for example, in the 1970s, there were young women who all of a sudden were presenting to physicians with a form of cancer, vaginal adenocarcinoma. Well, this was unheard of. There was a little bit of it in older women, but it was unheard of in young women in adolescence or their early 20s. Researchers pretty quickly figured out that the cause was DES exposure in utero. That is, if you found this cancer in a young woman, it was a signature for exposure to DES in utero. Well, mesothelioma which is one of the diseases that both John and Bill talked about, is a signature disease or nearly so. Nearly so. You adverted to something in Turkey. I'm going to stay away from Turkey. But 98% of the mesothelioma in this country is a result of asbestos exposure. And let me start by talking about that, because then, Bill, you were talking about where you have different diseases and backgrounds, and I think that was your reference to idiopathic disease as well. So for the moment, just to make it simple, so when is asbestos exposure a cause of mesothelioma? Let's suppose, as Bill was suggesting, that there is some threshold level of exposure that's required before mesothelioma will occur. And suppose we know that the level is 100, whatever, 100 parts, 100. Suppose that we have 10 defendants who each expose an individual to 10 parts, 10 doses of asbestos. Are each of them a cause of the plaintiff's mesothelioma? I think so, right? I'd go back and I'd say, take any one of them out, and the plaintiff doesn't have mesothelioma. Very simple. Easy. I wish it were that easy. Now, suppose in fact, and I think I'm taking issue with you here, Bill, suppose in fact that there is a background from the ambient air, non-tortious caused, of 10 parts, and 9 defendants contribute 10 units of dose. The plaintiff gets 100 and develops mesothelioma. Was the background exposure the cause of the harm? If we take it out, the plaintiff doesn't suffer mesothelioma, doesn't get to the threshold of 100. Yes, the background is a cause, but note that all of the other 9 defendants' exposure of the plaintiff are also a cause of the harm, right? So that background is interesting, but we don't care about it, frankly, in the same way we don't care about the genetic makeup of the plaintiff in a case, so long as it's non-tortiously caused. What we're interested in are the tortious causes. We don't impose liability on background or on genetic conditions. So now suppose that we have 9 that provide 10 doses, 1 that provides 9 doses, and 1 that provides a dose of 1. Now, I suspect that Bill would say, well, that 1 is not a substantial factor. I disagree. I think that 1 is a necessary condition for the outcome. That is, it is the straw that breaks the camel's back. Without that 1 dose, the plaintiff doesn't suffer mesothelioma. It is a cause of the harm. Now, having done that, said that, Bill, I'm going to come back because I do think there are some, as you put it, substantial factors that we can talk about. Okay, and this is where asbestos has really opened up our eyes. This is to people who are interested in causation, to the problems that exist in these multiple exposure cases. Now let me ask you, suppose that we have 11 defendants and each exposes the plaintiff to 10 doses. John, this is your situation where the defendant says, well, yes, I exposed some, but it was all the others that did it, right? And note that in this case, the defendant you're facing, John, is right. He says, all the others would have done it. I'm not necessary, right? And of course, with your bad luck, you face serially 11 people 11 defendants saying, with regard to each one, it was all the others that caused it, it wasn't me. Right? So we've got nobody who caused it.
It sounds like my life.
Yeah, it sounds like your life. Well, do y'all remember back in your first year of law school when you took torts and we had the situation of two fires that are negligently started and they burn and they join together and they burn down the plaintiff's house? Surely you remember that. At the conclusion of this panel, there's going to be an examination on that. This is classic. We refer to it as two fires. And of course, in that situation with two fires, neither one is a but-for or necessary condition. Why? Because if we take, even without the one negligently set fire, the other one would have burned down the house. Right? This is, Bill, you must have been the lawyer in those cases when they first came down, John, I'm sorry, when they first came down the road. This sounds familiar, right? This is your nightmares.
Close. It'd probably be 100 fires, but...
Okay, yes, right. And that's what asbestos has shown us. My example of 11 defendants who each contribute 10 doses is the asbestos variation on the two-fire situation. And it was the two fires that was the basis, the primary basis, for the use of the substantial factor test. That was where, Bill, we needed something other than the idea of but-for causation to express the case that, wait a second, that can't be so, that when we have two tortfeasors, each of them that could have been the cause, but is only not a cause because of the other one, they both have to be causes. And in the second restatement of torts, you would find the use of substantial factor to do precisely that. Each of them have to be a cause, a legally sufficient cause, in the same sense as a but-for cause, or, well, you can see the consequences. It would be perverse not to have that a cause. Now, here's where I think substantial factor, as Bill is talking about it, may have a role. And that is, suppose that we have 11 defendants, each of whom contributes a dose of 10. And we have another defendant who contributes a dose of 0.01. Okay? Now, I think each of those 11 defendants are a cause on the two fires case. But this 0.01 is a really trivial contribution to what we sometimes refer to as an overdetermined outcome. The two fires are an overdetermined outcome because it's determined by one and it's determined by the other. In this situation, we have a 0.01 dose. It is trivial in comparison to the others. And in those cases, we may be willing to say, as a matter of policy, I think, rather than causal theory, but as a matter of policy, we're not going to include that 0.01 as a cause. And I think the primary reason we wouldn't want to has to do actually with apportionment of liability. The problem is joint and several liability. If we had pure several liability in that situation, and if several liability applied on the basis of contribution to the risk, well, first of all, those cases wouldn't be brought because 0.01 of 100 is so small it's not worth pursuing that defendant, that this would drop out. But if it doesn't, if we still have joint and several liability or partial joint and several liability, as is the case in the majority of jurisdictions, a 0.01 may be interesting, particularly if 8 of the defendants, 8 of the people who provided a dose of 10 are no longer around because they've been through bankruptcy and they can't be sued. So I think it is the case, Bill, that there can be a substantial factor in this situation, but it is in where we've got a trivial contribution by comparison to a lot of others who contributed more. So the employee who worked for 30 years and was exposed to the top 10 insulation manufacturers' products, let us say, for 3 years at a time, or at various times over the course of her career, and then has a 2-hour exposure to brake gaskets because she was working on her car one day. That, it seems to me, is the paradigm for the notion of an insubstantial factor or a trivial contribution. Don't take those cases, John.
Right.
Avoid it. And to some extent, I think that was the cases, Bill, that you were referring to, that you had up there, the Gregg case from Texas, or Gregg was from Pennsylvania case, and the Texas case. These are people who had very small exposures compared to, I think, much larger exposures to other defendants that were defendants or bankrupts that were involved. Let me just say, I think what we need, though, for it to be an insubstantial or trivial factor is for it to be small in comparison to the other exposures. So suppose that we have 10,000 who each contribute a dose of 0.01. Provided that exposure of 0.01 was tortious, and it may not have been, but if it was tortious, it seems to me that each is a cause of the harm. Otherwise, none are a cause of the harm. Now, this is all very nice for me to say here before you. The difficulty, of course, with asbestos is we don't know what the threshold dose is. There's some threshold, whether it's one hit or it's multiple hits. There's some threshold. So there's some of these in asbestos, some exposures that are contributing to that threshold, and there's some that are irrelevant. But we don't know. And that's maybe not peculiar, but that's unusual to asbestos. That's the particular problem that we have with asbestos, is we don't know from the science that's available about what the threshold is. In fact, as you suggest, Bill, it's changed, right? From it only took one hit, right, to now we think there's some threshold. I'm quite sure it's a lower threshold than a lifetime of exposure that occurs to people who work with asbestos insulation or asbestos products over their entire lifetime. Let me stop because we've talked about this, to hear from the judges who are here, and I suspect also that Bill and John may have some disagreement with what I've said. Just one clarification of what Bill said about Paracelsus and the dose making the poison. And my understanding is that's absolutely correct, and that is a fundamental toxicology principle, 400 years after Paracelsus made that point. But don't misunderstand it. It doesn't mean that everything in sufficient dose can cause everything, right? Water, as Bill pointed out, water will cause death because in sufficient dose it dilutes your electrolytes and can cause death. You can take a straw to a swimming pool and you won't get cancer. It doesn't cause cancer. So yes, in excessive doses, agents it takes excessive doses for an agent to cause a problem, but they don't cause everything. Which is why when we look at asbestos, for example, the focus has been on 3 diseases, mesothelioma, lung cancer, and asbestosis, and whether asbestos causes a few other cancers is still in doubt. There are any number of outcomes that you could live with asbestos, and it's not going to cause you non-respiratory or cancer problems from the lungs down. To you. It won't cause you brain cancer. I don't think there's any connection between between brain cancer and asbestos. So with that, let me stop and